It was out of business. Did she ever
The first thing I said. COVID-19 mitigation measures are what make the schools safe. So we disagree with the CPU's position that schools aren't safe. But, Judge, if you want schools to stay open, you need to have school boards have the ability to have mitigation measures.
Thank you, guys.
Good morning, everyone.
Good morning.
Thank you. Have a seat. Just let me get set up here. Oh, I'm sorry. No, don't be sorry. Officer, we're gonna try and keep the doors open unless it gets noisy, just to help with air circulation. Okay. Yeah, so just in your discretion, if it gets noisy, then go ahead and shut the doors, but I'm trying to keep it cool in here. All right, so have all the attorneys signed in?
Yes. Yes. Yes, Your Honor.
So I'm gonna beg for everyone's indulgence because we don't know everyone's names. I do know some of you, but when you stand up, please identify yourself. Try to, Mr. DeVore, we know who you are. Mr. Berticchio, we know who you are.
Morning, Your Honor.
Good morning. I'm not used to you being back there. I wasn't sure where you were.
He left me. He was sitting right next to me, Judge.
And then I was looking for Miss Jones. Is she here? Oh, there she is. See, I didn't see you. Just for the court reporter, so that she can try and make an accurate record. And if you could remove your mask when talking, because that helps the court reporter as well. And if at any time you need a break, let me know. I've told the same of my court reporter and my clerk. Just don't hesitate to ask for a break. So, get this up here. And one administrative matter, is Mr. Cosley here? I don't know about anyone else, but whenever I email him, it never goes through, or it waits, or it, does everyone else have that problem? Okay. And I emailed him and tried to, I think I have his correct email address, but like today, I still got a thing, it's waiting to be sent to him, so, okay. So let's start out with 5002. We're here on the TRO, correct, Mr. DeVore?
Yes, ma'am.
And I think you had a quick motion on, is it an O2 on the affidavit?
Yes, ma'am. There's a request. We asked for leave to present to the court the affidavit of a doctor, and you granted us permission to present that to you this morning. I have a hard copy for you, printed double-sided if you'd like, as your request was to me.
Yes, can I have that, please?
May I,
Yes.
clerk? And Judge, as you consider that, Mr. Feeney and I talked briefly, and 5002 and 5005, which is the Montgomery County School District, the Hillsborough School District, that I believe him and I are in agreement that the arguments that are made in 5002 would overlap into 5005, even though the masking and not the exclusion is the only issue in the Hillsborough case, that again, the arguments will be identical to the masking arguments made in 5002. The only reason that that case, Judge, was not dismissed and then consolidated in with the case is because there's a class certification
Well, that's right.
in that case already from Judge Drunke, and so.
That's 5005, right?
Yes, but to the extent the court's going to consider the arguments of whether or not a temporary restraining order is proper, Mr. Feeney and I agree that the arguments made in 5002 would be duplicative and don't need to be done twice. I think that's what you would agree to.
That's accurate, Your Honor. I'm here on both 02 and 05. 05 is a mask-only case. There's not a close contact option, but there's no need for us to do the same argument twice for the
Wonderful.
court. As long as there's something in the record in 05 that would reflect, that the arguments in 02 are there so that we have a clean record.
Yep.
If we have to address this beyond today.
Let me make a note here so I don't forget. I'll do a docket entry that reflects that. Okay. Now, any objection for the motion for Lee to file this affidavit?
Your Honor, before you address that, could I address another administrative matter?
Sure.
Thomas Verticchio for the Attorney General on behalf of the state parties. Mr. DeVore and I spoke yesterday, Your Honor, picking up on the conversation that we had at the end of the hearing Monday afternoon in 50,007. I believe we have a joint motion for you. I haven't had an opportunity to address this issue with other defense counsel, but my guess is there won't be an objection. And the joint motion is that so that we can avoid duplication, or more appropriately, exhaustion, we are moving that the transcript in the Allen matter, 50,007, be allowed to be filed of record in the Austin matter, 50,002, and Graves, 50,003,
Three, yeah.
and Hughes, 50,005, with your permission. And likewise, so that we know that we have a complete record in all the cases, we were making a joint motion, the plaintiff and the state defendants, that the transcript from this proceeding be considered as part of the record in the 50,007 case, so that we don't have to debate, did I say that? Yes, turns out I said it in a different case. So with your permission, that's the joint motions, that the transcripts from all those proceedings be filed and be considered part of the record in each individual proceeding.
So just let me clarify, because I haven't looked yet at 04 and 06. Do we want that in all of them, or just the 02, 03, 05, and 07? I don't know if
Your
anyone
Honor-
can elaborate.
Your Honor, Luke Feeney, we're for the district and superintendent in 06. There's nothing said in 06 today, and I don't believe
Right.
Ms. Hager is here. I haven't seen her.
I'm
We-
just
we
trying
would
to
have-
cover all cases, just
We
in
would,
case.
from the defense side, we have no objection. I've not spoken to Ms. Hager about it. She's not here, so I can't speak for her.
Okay. And I haven't even read those, so I don't even know the issues yet. Are you in one of those?
No, Judge, this is Will Gerber
Oh,
in 03
Yes.
for Graves. We have no objection, and I would indicate the due process arguments associated with 03 are going to be duplicative of 02 and 07.
And how about
06,
5?
or 05, I'm sorry. So, for
That's what I
purpose-
thought.
For purposes of exhaustion, also, Judge, I think the transcripts would be beneficial for 03, so I'm not speaking for another 45 minutes associated with that case as well, so.
Thank you. So is there any objection to Mr. Verticchio's joint motion? I suspect there's not, but, so I will do a docket entry then that the transcript from Monday in 5007 will also be the record in today's hearings, which are 5002, 5003, and 5005. And then today's hearing will also be part of the record in 5007, which is Allen, correct?
Correct. Thank you, Your Honor.
Okay, thank you. So now let's go to Mr. DeVore's motion for leave to file the affidavit of Dr. Daniel Stock and Stanter. Any objections?
Your Honor, I have an objection.
And you are, sir?
Your Honor, Robert Swain. I'm here
Thank
this
you.
morning on behalf of NES School District 34, Arlington Heights District 25, Cary School District 26, Crystal Lake School District 47, Marion School District 2, Mount Prospect School District 57, Prairie Ridge School District 46, Township High School District 117, Township High School District 155, and Waterloo School District 5.
I'm impressed you had all this.
My clients would be quite disappointed if I didn't, Judge.
You didn't even look at a piece of paper.
Judge, I've read the declaration from Mr. Stock, or from Dr.
Yeah.
Stock, and here's my concern. It is a declaration about 2 pages long, purporting to state that there are health dangers presented to students by masks, which I find to have no relevance to the TRO and the complaint that is before the court today. The complaint has 477 paragraphs. Not a single one of the 477 paragraphs suggests that students suffer any medical harm from masks. I can appreciate the concern of parents, but that's not the complaint that's here before the court today. It's not the TRO that we have here today. The complaint that has been filed, the TRO that has been brought, are to assert purported due process rights on behalf of students, not to litigate medical issues about whether masks do or do not pose danger to students.
Thank you. Mr. DeVore?
Judge, that has nothing to do with the ability for it to be submitted to the court and the court to accept it into the record. And if they want to argue at a later time that they don't believe that there's any relevance or it shouldn't have any merit, that's a separate conversation. That doesn't preclude the court from recognizing it. And to the extent my colleague wants to say this is all about the law, I don't necessarily disagree with him. But if the court looks at the hundreds and hundreds and hundreds of pages that a lot of the defendants submitted, they go down that rabbit hole of talking about, the medical catastrophes that are going to occur should the court grant this injunctive relief. So I could stand here and say striking all of their hundreds of pages is necessary too, because it's not relevant to the issues of law. But again, if Mr. Swain wants to argue at the court how it might consider that affidavit, that's a separate conversation. It doesn't have anything to do with its admissibility in the court accepting it into the record. Thank you.
Okay, thank you. Any other objections?
Your Honor, William Picorni, our firm has appeared for 17 school districts, including the Chicago Public Schools. I don't know if you want me to list them all off right now.
That's okay.
To the extent that the court is going to entertain counsel's motion to submit this affidavit, Chicago Public Schools, at the very least, would like an opportunity to submit a counter affidavit from its own medical expert. The affidavit that Mr. DeVore is asking to submit really, frankly, should have been part of the original pleading, the motion for TRO that was filed. We understand in the press of filings that it may not have occurred, and perhaps there's reason for it only being filed now. But it is essentially new arguments being raised in a reply brief to which the defendants should have an opportunity to respond. So we'd simply ask for an opportunity to submit our own affidavit replying to the arguments that are raised by the doctor in his affidavit. Thank you.
Mr. DeVore?
Nothing to respond to that, Judge.
I'm gonna go ahead over.
Your Honor, I thought you were going to ask if there were other objections.
Oh, I'm sorry, I thought I did. Sorry, go ahead, Mr. Verticchio.
On behalf of the state parties, we join in both of the objections and also, perhaps more importantly, join in the request for an opportunity to file a rebuttal declaration in the event the court is going to consider the declaration as part of the TRO proceedings. If you're not going to consider it as part of the TRO proceedings, then it can be dealt with later. But if you're going to be considering it as part of today's hearing. Mr. DeVore told us yesterday, when he told about how he's been battling these issues with Ms. Satterley since the summer, the matters pending in Macoupin County and throughout the state, and yet the day before the hearing in this consolidated action, he files an affidavit, a declaration. That's gamesmanship, and if it's going to be allowed by the court, I understand, because I understand the court wants people to be able to make their record. But in fairness, the parties on the other side should have an opportunity to file a counter affidavit, and it certainly wouldn't take long, a matter of days, I would guess. But we request that opportunity. Thank you.
All right.
Judge, may I be heard?
And who are you?
My name is Lisa Callaway. I'm here on behalf of 31 of the defendant districts.
And you don't need to listen, but thank you.
I couldn't, because I'm not sure I could. I would join in the other, the state's objections as well as the other objections that have been made. We were all in receipt of a frankly unprofessional communication received from Mr. DeVore last night about what he claims to be gamesmanship and last-minute filings. I have not even seen this motion for leave, and I think that at a minimum, the defendant should be given an opportunity to review that affidavit and file a response. Thank you.
You're welcome. Go ahead.
Will Gerber again, in 5003 Judge for Graves. Respectfully associated with the state's comments, at about 7:30 last night, we received an affidavit requesting to be placed in the file from a medical doctor by the state defendants that I think is probably going to be addressed associated with our TRO, associated with the gamesmanship argument. So in the event, I guess, if the state's objecting to the placement of this medical affidavit associated with the transcript in this proceeding, the same objection, I guess, should be made by the state associated with their request to put the same type of affidavit in the file both for Mr. DeVore and myself.
Your Honor, the notice of filing last evening regarding the affidavit that Mr. Gerber is referring to was a matter of convenience for this court. It's been the law for 100 years or more in this state that the court can take judicial notice of records in its case. And then there was a debate for decades. Well, does that include the records in the other cases in the courthouse? And in 1974, the Illinois Supreme Court said that's a silly argument. In People versus Davis, 65 Illinois 2nd, 157 at page 161, the court clearly held that you, as a judge sitting in these cases, can take judicial notice of the records in the Sangamon County Circuit Court. The affidavit that Mr. Gerber refers to was filed on September the 24th in the case of Cornaya versus Pritzker et al. In Kane County. That action was transferred here. It is now consolidated in the matter before Judge Asher in the Lambert matter versus Pritzker, 2021 MR 1283. It is already in the records of this court and has been for some time. The court can take judicial notice of it. It was filed as a matter of convenience, frankly, Your Honor, so you're going to have to go track it down.
Thank you.
Thank you. If I may?
Yes.
Hi, I'm Fraser Satterley. I'm here on behalf of Yorkville 115, North Mac, CUSD 34, and Woodstock 200, Your Honor. I join in my colleagues' objection to the declaration of Dr. Stock. I'd also note for the court that the First Amendment complaint here lacks any specific facts with respect to any specific plaintiffs. Dr. Stock's declaration also lacks any specific facts about his ability or his opportunity to examine or observe any of the students who are named plaintiffs in this matter, Your Honor. So to the extent the court considers that, there are no specific factual allegations in that declaration, and we object on that basis as well.
All right. Thank you. Any other defendant?
Luke Feeney, Your Honor, will object in 02 and 05. Thank you.
I can note that for everyone if you want. Everyone objects in 02 and 05 and then 03. Counsel, I can't see you, sir. Sorry.
Yeah, sorry. A little light over here. Randall Slater on behalf of 11 school districts. I just wanted to join my colleagues on the defense side's objections.
Okay.
Nothing further to add.
And then from you, Mr. DeVore, anything?
No, Judge, I don't have anything else to add. I think the court sees, we're talking about, I kind of agree with Mr. Swain, the issues of this medical stuff, is it really relevant, issues of law? And to the extent, again, I think Ms. Beesdale is her name, who submitted, you've seen it not only in the state's pleadings, but in the Illinois Education Association's pleadings. She gives the same kind of opinion medically too, and I think they asked last night to submit her 80-page curriculum vitae too. So, again, accepting ours in, the court can accept it and take it for whatever it feels it's worth. There's no reason not to put it in the record, and the court may choose not to consider it or Ms. Beesdale or any medical opinion when rendering this decision in this TRO.
Okay, I'm going to allow it over the defendant's objection. It can be filed in stanter. I just asked Mr. DeVore that when you go back, if you would file it or have your assistant file it so that it has the clerk's stamp on it. So could you file it through the e-filing system after today?
I think she did that first thing this morning.
Oh,
ma'am.
wonderful.
I'll double check to make sure.
If she already did it, then we're good.
I think so, ma'am.
And then if the defendants want to file any affidavits, if you want more paper for me to look at, then you have 7 days to file it. Anything not filed after, what's the 7th day from today?
The 12th, ma'am?
After the 12th, at about 4:30 p.m. will not be considered.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
All right. So now are we ready? Anything else administratively? We ready to proceed then on 02, 05, and 03, I guess? All right, so we'll start with you, Mr. DeVore.
Do you want to start with the TRO or the class certification request, Judge?
Which will take less time.
Probably the class, I'm guessing, Judge. For me, it will at least.
Let's do that, because maybe we can get that done this morning. And then maybe we can then start fresh after lunch with the TROs.
Yes, ma'am.
We can aim to get it done in even less time than that, but. All right, let me
Don't
make.
snark, Tom.
Okay, I'm ready, Mr. DeVore.
Your Honor, I have a copy for you. If you haven't seen it already, I would hand you. I know everybody else has probably seen it. It's the order that was issued by Judge Tromper in the case that was the 2021 MR 91, at least as it related to the North Mac School District only and not to the rest of the school districts. I don't know if the court has a copy.
I do not here on the bench with me, but I do have
You want
one,
a
so,
copy?
yes. If you could.
Judge, and all I do is I know you have it, it's just when you get a chance before ruling on this issue, take a chance to read that. She does.
Your Honor, there were obviously several rulings by, Judge Trumper. Could we have the benefit of knowing which ruling it is?
It's the only one that she
The date.
issued on class certification.
And it's dated September 21st of 21 in 21 MR 91.
Thank you, Your Honor.
You're welcome.
Your Honor, and again, exact same fact pattern, at least as it related to the North Mac School District, as it relates to the other school districts that you have in front of you here today. She goes through in detail all of the elements and lays out her reasoning for why she felt, under the circumstances, that class certification was appropriate. And again, I could go through all of the elements if the court can ask me any of the questions, but here's the practical issue, Judge, as it relates to the certification of this as a class, which I think the court should absolutely do. What happens if the court doesn't certify the class? That's really the question, because one of the things that she talks about in her order is the appropriateness of class certification. The court should consider whether this type of action best promotes uniformity and saves time, money, and effort, or otherwise accomplishes the ends of equity and justice. I start with that, and then I also start with, well, if you don't have class certification, what do you have? Then you have potential joinder of other party plaintiffs. All persons may join in the action as plaintiffs, in whom any right to relief in respect to or arising out of the same transaction or series of transactions is alleged to exist. Now, we kind of had a little bit of an overlap with this, Judge, when we were talking with Ms. Haggard, when we were arguing about the ability for those who disagree. Should the court grant the injunction, hypothetically only? Those who disagree and say, regardless of what the court rules, we're going to wear our masks, or if we're told that we have to be excluded, we're going to be excluded. We don't care about due process. There's no purpose for those persons to try to join or intervene because there's no benefit to them. But when you say we have persons, some amount of persons in this, I believe the math has been done by myself in the state, of these 146 school districts, almost 900,000 children. And the court says, well, we're not going to certify a class. Then what happens? You're going to have tens, if not hundreds of thousands of parents filing requesting to join this action because they have a right to relief in respect to or arising out of the same transaction. They want due process for their children. They're going to ask to join. And again, I know of no reason why the court wouldn't be able to allow them to join. Because that's the analysis that the court does on class certification. Should I certify as a class, or given the 4 requirements, would it be more appropriate to require joinder? And again, man, for that straight reason alone, merely because of the efficiency of the system and justice, class certification is appropriate. I mean, this is a quite straightforward question. Is a parent, on behalf of their children and the children themselves, entitled to due process under the law before they can be required to wear a mask, to limit the spread of infectious disease, or for them to be quarantined, excluded from school? We'll get into that later. Without due process of law. That common question is common to every one of these parents and kids in this proposed class. It's exactly identical. And again, when you read the order of Judge Trumper, you'll see that. I mean, that's really what we're talking about. And again, Judge, if the court decides not to certify a class, we're stuck with a massive joinder across the state. And again, I don't know that the court system wants to get 2 or 3 or 400,000 requests to join from parents across the state. Now, my colleagues are going to stand up here, I have no doubt, and they're going to give all of the reasoning on why certification shouldn't be done. The one thing they won't say to you is, we don't want you to do that because we don't want these other parents to have the protection of the law unless they jump through a bunch of hoops. That's what they really want to accomplish. They want to have the least amount of parents/children in their school districts protected by due process, should you grant, hypothetically, the injunction. They want to minimize its impact. That's the truth. But again, they can't say that to you, so they're going to say, well, one of these elements is not met. The elements are easily met. And again, I could not articulate it to you near as eloquently than what Judge Tromper did in her 8-page order. I asked you to read it before you make any ruling, ma'am.
Okay.
But again, she covers the elements are clear, and again, she was just dealing with one school district of 1,000, 1,300 kids. We here have 146 school districts with hundreds of thousands of children. And again, the children and the parents of these systems, and you're going to hear some of this, well, what about all of the parents and children who don't want this? This case doesn't impact them directly. Does not, and that's important, ma'am. It doesn't impact them directly
Because if you grant the injunction that says due process is afforded, doesn't mean they can't put a mask on their child voluntarily. Doesn't mean that if the school district comes to them, like they do, I'm sorry, I have to take this off, and says, oh, your child's been deemed a close contact, go home for 10 days. And a parent can say, regardless of this court's order, okay, get to go home. Those who would disagree with this court's ruling, what they're really wanting to accomplish is for you not to give those rights to the other parents. That's what they're really wanting to accomplish, and that's, again, what my colleagues are going to try to get you to do without certifying the class. So we'll have 700 and something, 800 and something, whoever the party plaintiffs are, well, they're the only ones, at least initially, again, assuming the court would grant relief, initially that are protected. And then they'll be thinking, well, it'll take a long time for all those people to ask the court to join. And so that's what, again, they're trying to accomplish, man. And again, class certification, as Judge Trumper said, you're trying to protect the small person. And she found there is no smaller person than parents and students who would be protected by class certification. And for those reasons, man, we ask that you grant it. Thank you.
Thank you.
Your Honor, Robert Swain on behalf of my 11 clients.
Can you recite it again? No.
I'm able, sir.
All right, Mr. Swain, go ahead.
I do congratulate Mr. DeVore, because if there were any parents left in the state who had any desire to join this lawsuit, then Mr. DeVore surely would have found them, as evidenced by the fact that we have so many hundreds of parents representing so many thousands of students from every corner of the state, from 145 different school districts, having already joined this lawsuit directly through some fairly aggressive word of mouth about the fact the lawsuit was being filed. So I don't have fears about tens or hundreds of thousands of people hiding in the wings, unaware of the proceedings today, I think is evidenced by the courtroom and by the fact that you found the need to even have to live stream this for the many folks throughout the state who are so interested in it. And I also expect, certainly, as I think we all can predict, that whatever ruling the court might enter is most certainly to be appealed by one side or the other, and that within the course of a few days, given the expedited course, of course, of expedited appeal of a temporary restraining order, whether granted or denied, that we will have appellate level authority telling us what the law is. And that will answer the questions here for every school district, every parent, every student, every educator across the state once those appeals are finished. So I don't have concerns, I don't think there's reason to have concerns about this turning into any more of a, I don't mean this is like, but any more of a production than we already have here in front of you, Judge. That is certainly, I think, not likely to happen. On the flip side, to compare this to the proceedings in front of Judge Tromper, to which I was not a party, but it's quite evident. That was one lawsuit pending by one group of parents from within one school district against just one singular school district. And you have here now 145 new school districts added by way of joinder into the same lawsuit. And that presents, as I think you'll hear and understand a lot better as we get into the merits, which Mr. DeVore has already previewed quite a bit this afternoon on the TRO itself, some real problems in terms of commonality. Because what we hear this morning is that of these 146 school districts, without even having to get into all the issues that so many of us sat through on Monday concerning state level authority, those 146 school boards elected to run those 146 school districts all have independent authority to adopt local policies. They all have.
Quick, please don't. Sorry, Judge. Apologize.
Go ahead, Mr. Swain.
They all have chronic disease policies. They all have return to learn plans, okay, that have been adopted, updated, implemented over the course of this pandemic, some 22 months now. And to try to get into adjudication of whether individual students have actually suffered a deprivation of, say, liberty or property, or whether they actually have been denied due process, if there even was a deprivation in the first place, or whether there's any relief that needs to be afforded, is then going to come down to an examination necessarily of those individual circumstances and of the individual plans being implemented by those individual school districts in 146 different corners of the state. So I confess I'm not party to Judge Tromper's order. Having read her other materials, I'm sure it's quite thorough. But I can't, and I don't believe we can, try to extrapolate a ruling on class certification, which presumptively found commonality when there was a class of parents in one school district involving one return to learn plan, and then try to extrapolate to 145 other school districts throughout the state, each with their own separate plans.
Okay, this is what I'm gonna do, because there's so many defendants. So after each defendant, I'm gonna give Mr. DeVore a chance so I can keep my notes straight, okay?
It'll just be brief, Judge. As to the first thing that my colleague says about the number of plaintiffs currently listed right now, to suggest that they could have been included. Judge, if I'd had all the time in the world and a staff the size of the Attorney General's office, I could have had 1 million parents listed as plaintiffs. You should have seen the clerk's office trying to get 711 parents into the system. They crashed the system, and they actually had to have whoever deals with that fix it. What if I would have had 500,000 parents or 1 million? It was ridiculous. So to suggest that we had the time and we could have added these folks, again, it's almost illogical. It doesn't make any sense. But certainly, it was not for a lack of people not wanting to participate. As far as the analysis that's made, well, Judge Tromper was looking at one school district, and this is 146 school districts. Judge, that's just, again, trying to divert the conversation to something that it's not, because all of these school districts are doing the same thing. They're requiring kids to wear a mask, and they're excluding them from school, none of them getting any due process under the Department of Public Health Act. That's common to all of them. Doesn't matter if they have some unique policy that has words in it that another one doesn't have. The commonality of the law is the same for all of them. There's no due process given to the parents when it comes to mandating masks and to excluding their children. That's common to all of these school districts. Thank you.
Who's next?
Your Honor, William Picorni for the Chicago Public Schools, and 16 other defendants. We'll get into this more when we talk about the temporary restraining order, but the court should take judicial notice that the Chicago Public Schools are closed today, because last night the Chicago Teachers Union voted that the teachers were not comfortable coming into school, even with the precautions that the plaintiffs now seek to block through this lawsuit. Now, obviously, Chicago is a very large and diverse community. There are 330,000 students served by the Chicago Public Schools. I guarantee some of those parents have opinions that differ strongly from the opinions that are being advanced by counsel in this case regarding the precautions that school districts can and should be permitted to take to combat the spread and limit the spread of COVID-19 in the schools. The issues that are before this court affect far more than the individual students, being allowed to have a choice of whether to wear a mask or not, or comply with a direction from a school to stay home from school as a close contact. We've presented evidence in the form of affidavits from Dr. Allison Arwady and Dr. Alexandra Sontag explaining how masks affect others in the school. Masks are there not primarily to protect the individual wearing the mask, but to protect others around them. And they're most effective at combating the spread of COVID-19 when everybody in the school environment is wearing a mask. So for counsel to stand up here and say that, oh, well, other parents can simply choose to put a mask on their kids, that's simply false. Everybody is affected by infectious disease, whether we like it or not. And the presence of individuals without masks in a congregate setting like a public school affects everybody else. Likewise, the presence of somebody who has been a close contact of somebody with COVID-19 affects everybody else in that school. So there's both health risks for the other students, even if they continue to wear a mask, even if they're not a close contact by having those individuals present. But also, as the action by the Chicago Teachers Union shows, the actions of this court and the ability of school districts to take action to protect school teachers and students affects whether schools can stay open. Again, Chicago Public Schools are closed right now. So council has an obligation in order to certify a class here to show that the class representatives, the plaintiffs in this case, the named plaintiffs, will fairly and adequately represent the interests of the entire class. We're talking about something like 900,000 students, all the parents of those students. You know, we're talking about potentially millions of class members here. So for council to stand up and say that this small group of a couple hundred, you know, I don't even know what the full count is, but you know, those several hundred individuals who've brought this lawsuit are representative of all the parents across the state is simply inaccurate. And for council to say that, well, other parents can simply disregard this court's orders and have their kids wear a mask or stay home if they're a close contact ignores the actual effects of COVID-19 on the entire community and on the ability of schools to stay open. So, you know, for those reasons and the reasons stated in the written brief, we do object to the class certification motion. Thank you, Your Honor.
Thank you. Any response, Mr. DeVore?
Judge, most of what my colleague just recited to the court has nothing to do with the law. He quite eloquently talked about the practical impacts from his perspective. There are many that would disagree with him, but I don't need to. The impacts of COVID-19. I never really heard him say much about why class certification is not appropriate under the law. It's just, well, that could have a bad result. Judge, the class certification, what all people have in common, everybody on this planet, at least in this country, in this state most importantly right now, have the right to due process. They all have it. They may not want to exercise it. They may not want their neighbor to exercise it, which is really what my colleague is referring to, is that those who think masks are a good idea, that sending kids home because the school administration thinks they're close contact, that's all. We need to do all that stuff because of the practical impacts of COVID. Judge, I'm sorry, but we've got to set that aside. I remember the first day I walked into Judge Tromper's courtroom and she told Ms. Frazier, or Ms. Satterley and I, we're going to talk about the law. And that's what I'm asking you to do. Let's talk about the law. And the law gives due process. It's common to everybody. And again, the practical impacts of COVID, which we could all quibble about, doesn't even come into the conversation. Thank you.
All right, and who are you, counselor?
Jennifer Smith, arguing on behalf of Plainfield School District and the school districts that joined in their argument.
Okay, go ahead.
And Your Honor, the point I want to raise is that counsel has said that all students have to wear masks, and he's just arguing for due process. That's not the status quo. All students do not have to wear masks. Our clients have processes to give mask exemptions and mask accommodations. So there is our most vulnerable. Counsel talks about the little guy, looking out for the little guy. The little guy, the student who has a disability that makes it so they cannot wear masks, they do not have to wear masks today. But if everyone else doesn't have to wear masks, that accommodation, that exemption becomes dangerous. So it's not just the due process for the kids who everyone's wearing a mask. That's not what this is about. They're seeking to represent, perhaps, by certifying class, the family with the student who has a mask exemption, who went through due process. We have a process to offer exemptions for families, and you'll see in the affidavits, the families that have filed this suit, many did not follow that process. There's a process. It doesn't have to be this court. We offer an administrative process. There are students with exemptions, and they should be considered when you're considering whether to certify the class.
Anything, Mr. DeVore?
Judge, my colleague misses the point. When she's talking about mask exemption or accommodations, she skips over the whole point of that presumes that you have to wear them unless we decide to exempt or accommodate you. Think about that. Disregard the law and due process of whether or not you even have to wear one. She jumps over, we're already telling you you have to, unless we decide to exempt or accommodate you. Judge, that's all I have to say about her comments.
Mr. Feeney?
Luke Feeney, Your Honor. I'll hold on the due process till this afternoon, but I think there is an issue with element number 3 of the class rules, which is that the representative parties will fairly and adequately protect the interests of the class. I think the problem comes with the voluntary compliance. Counsel has said that the fix for that is that parents can have students wear masks if they choose. And I think the reasoning of the Northern District of Illinois in the Trogstad case, that case was a vaccination and testing case, but the reasoning applies here. The court said, indeed, when confronted with a widely contagious pandemic, plaintiffs are not asking to be allowed to make a self-contained choice to risk only their own health, given that their refusal to be vaccinated could sicken and kill many others who did not consent to their decisions. It's a Northern District federal case, but I think that logic is equally persuasive here on why the voluntary masking would not comply with element number 3. Thank you.
I'm sorry, Mr. Feeney, will you repeat the name of that case law, just the last name?
Trogstad, Troogstad. We've cited it in our brief. I believe the state cited it, Judge. I'm sure several of my colleagues have as well. I can dig out the citation if you'd like.
I have it. If you want it, Madam Court Reporter, we can get it for you.
Okay, thank you.
I believe Mr. Feeney, Your Honor, tried that same argument with Judge Drunke, and it was unsuccessful. That federal case wasn't dealing with the provisions of the law that we're dealing with here today. I've not read that case in every word, but I know it's not directly on point to what we're dealing with. But nonetheless, that was tried and failed. And again, Judge, the common theme that all my colleagues are giving to the court was, well, how could the members adequately protect the class? How could they fairly and adequately protect the class? They're trying to conflate it, Judge, because what we're talking about is protecting our due process rights. That adequately protects everybody. Now, what they're trying to say is what you can't protect is those who disagree. Those people that not only want their kids to be masked and their kids to be sent home based upon a whim, is we want that to be forced on all of you too. They're saying we can't fairly and adequately protect them. Judge, that's not even a part of this conversation. That's a completely different set of circumstances altogether. Again, they're trying to bring practicality into it. They want to use this argument to say, well, all these people who may not agree with the court's ruling, they don't want you to they don't care about it really, but they don't want all of these other people to come under the court's protection. Because if the court doesn't bring them under their protection, those people are still stuck dealing with these measures that the school districts have put in place. If you don't protect them with class certification, they're still stuck with, if you don't put them, as Mr. Verticchio, he moved on, he's over here now. If you don't have to wear a mask, he said, we kind of got into that the day before yesterday, if you recall, just briefly. They don't have to wear a mask. If they don't wear one, they just have to go home. So you don't get your education. If you don't bring them under the class, Judge, that's what they're going to deal with until they have a chance to join.
You're on a very, very minor point that I could chase down the dates if necessary, but the Trogstad case was decided well after any class issues had been considered in North Mac, Hillsborough, or Carlisle.
Okay. Anyone else? Mr. Verticchio?
Thank you, Your Honor. On the North Mac case, I think Mr. Swain was the one who pointed out that that's a one-party plaintiff case, it's a one-party defendant case. That case is so far afield from this room, it's laughable. Beyond that, in the North Mac case, the order that Mr. DeVore just handed you, was it September 22nd?
First, I think, or second.
I think on the same day, she entered an order, Judge Trumper entered an order, saying that the state parties were necessary to the case.
That's correct.
The Lurkins Court tells us, and it's binding on this court, 5th District tells us, because of the necessary party status of the state defendants, that the orders entered before the state defendants were parties were, quote, entered without jurisdiction over those necessary parties and void and must be vacated, close quote. Whatever impact the North Mac ruling had in that case, it has no impact here. The case is dramatically different in terms of parties. And beyond that, Lurkins tells you it's void. Mr. DeVore told you, let's talk about the law. Okay, let's talk about the law. Due process. You're going to hear a lot about due process this afternoon. We've heard a lot about it this morning. I'm not sure why. But it is front and center on this motion. There are, seems to be a moving target, but I believe 152 parties to this case. That's not right. There's 152 defendants to this case. You entered an order on December 15th, 2021, instructing Mr. DeVore to report to the court when service of summons had been effectuated on every defendant. It's a lot of them. We haven't heard from Mr. DeVore. Why? Because either service of summons has not been effectuated on every defendant, but more importantly, for those that have not appeared, even if they have had summons served upon them, their time to appear has not run. They are not before this court. This court lacks jurisdiction over those parties. Mr. DeVore is asking you to enter, by any standards in our jurisprudence, a case-altering order impacting every named defendant, all 152 of them, many of which you do not have jurisdiction over. They're not here. They have no obligation to be here. They've either not been served with summons or their time to appear has not run. They are not here. And as a result, the court lacks jurisdiction. This is black letter law, Your Honor.
Explain this to me then. I got a notice the other day that I'm part of a class action for my FOIA card. I had no idea the case was pending. Presumably, I'm a party to that because they sent it to me because they've settled it, and I have a right to participate in the settlement. So how is this any different?
Because you're class member, Your Honor, you're not a defendant. If you would have been a defendant in that lawsuit and somebody certified a class, they just stomped all over your due process unless you had been served and your time to appear had run. You're a class member who went through the process as an absent class member of a certification. I can guarantee you, if you look up, if it's a federal case, if you look up that case on PACER, you will conclude that every defendant named in that case appeared and the court had personal jurisdiction over them at the time class certification was entering.
That's helpful.
Illinois Supreme Court, Your Honor, in Ray Dar, quote, if a court lacks either subject matter jurisdiction over the matter or personal jurisdiction over the parties, any order entered in the matter is void, ab initio, close quote. The City of Bloomington case, these are all cited in our opposition, Your Honor. Illinois Supreme Court, quote, "Where a court lacks personal jurisdiction, the proceedings are a nullity, and no rights are created by them, and they may be declared void when collaterally attacked." Plain and simple. There are many, many defendants. My guess is Mr. DeVore doesn't even know how many defendants you don't have jurisdiction on. You simply, it would violate the due process of each of those parties for the court to enter an order certifying a class against them when they're not even here. That preliminary issue requires that the motion either be withdrawn, continued, or denied without prejudice. There's another preliminary issue. Discovery. Mr. DeVore just told you his count. We talked earlier before the court proceedings. I believe Mr. DeVore's count is 714 plaintiffs. Our count's a little more than that. There's 150 defendants. The reason is I think he counted parent. I think he counted parent plaintiffs as one. We count them as two.
Okay.
Reasonable minds can differ, I guess.
You said 150.
Depends on household, I think, Your Honor.
150 defendants you counted?
There's 152 defendants by my count.
152, okay.
Mr. DeVore told you that this case impacts 900,000 students. Roughly then, you're talking somewhere in the neighborhood of, I don't know, 1,600,000 parents and 1,800,000 parents, somewhere in there. And I'm holding in my hand the motion for class certification, in this case, of over 1,000 plaintiffs, over 150 defendants, impacting over 1 million students and almost 2 million parents. This is it. That's the whole thing. These parties, Your Honor, deserve more, much more, from the movement who wants to certify a class impacting millions of citizens of this state. Here's what the appellate court said in Lee, Your Honor. It's 219 Illinois Appellate 5th, 180033, paragraph 54. Quote, "In a class action, the trial court is the guardian of the interests of the absent class members." Of the absent class members. By Mr. DeVore's count, there's about 800,000. And if we're counting parents, there's somewhere between 1,600,000 and 1,800,000 of them. They're not here. They're absent. This court is the guardian of them. To certify a class with no discovery whatsoever, giving the parties an opportunity to determine who are these parents? What are their beliefs? I'm going to take depositions. Class discovery, I need to know, who are these parents? What do they think about things? Do they think COVID is a hoax? I guess some do. Do they think I'm done with COVID? I'm just done. And therefore, forget masks, forget mitigations, I'm done. I think some do. Absent class members are entitled to know that. I'm entitled to know that as a representative of the state, to make a determination and an argument to you that these plaintiffs do not adequately represent this class of 800,000 students and 1.6 to 1.8 million parents. Discovery on who they are, what they believe. Also, again, Your Honor, this is the motion. This is the motion. There's one line in here. Counsel's adequate to represent the class. I've never seen a class motion like this. And I've been doing this longer than I care to admit. There is There is no evidence in this record that Mr. DeVore is qualified to represent a class of millions of people. It's not here. Maybe he is. We've given you the exhibits in our opposition. You want to check his website. There's no mention of class experience. And your honors had many class actions, I'm sure. It's a field of expertise. And when you get motions to certify a class, they are like this. They are this. And the qualifications of class counsel go on and on and on and on. It just makes you sick. It just goes on and on. This is it. Discovery. Adequacy of counsel. So for those two preliminary matters, Your Honor, no jurisdiction due process. It's black letter. And lack of discovery. This motion is just premature, period, end of story. But if you want to consider the merits, the Illinois Supreme Court in Weiss instructs, and it's at 208 Illinois 2nd, 439 at 450. In order for a party to have a class certified, it is incumbent upon that party to plead and prove the four elements of class certification: numerosity, commonality, adequate representation, appropriate vehicle. It's 2.801 of our Code of Civil Procedure. Everybody knows it. Plead and prove. Well, it's certainly not pled. I would go to the exhibits to this to see if it was proved. There are none. Plead and prove. Should be summarily denied for that reason. The Weiss Court, Illinois Supreme Court said, Your Honor, that a motion for certification of class, quote, is brought by a putative class action plaintiff who asks the court, based on the evidentiary materials adduced through discovery, to find that the case can proceed as a class action. Close quote. The Lee Court, Illinois Appellate 5th District opinion, 2019, Illinois Appellate 5th, 180033, paragraph 53. Quote, in deciding whether to certify a class, the trial court may consider any matters of fact or law properly presented by the record, including pleadings, depositions, affidavits, answers to interrogatories, and any evidence adduced at hearings. We don't have, I've never been to a class certification hearing where we didn't have witnesses. This is a remarkable thing. We're not talking about a class of 50 people. We're talking about a class of millions of people. Commonality. You have the state parties and executive orders. You have 100, I think it's 47 districts, and they have their procedures. Several of them, many of them, that are before you, have filed briefs outlining their positions on things, regardless of the state proceedings and the state executive orders. There's no commonality to the issues. It's just not there. Adequacy of representation. Mr. Feeney hit on it. This is the one that it's really striking. These are voices, loud voices, of a minority view. Somewhere between 700, 800 players. I don't know. We have a declaration in our opposition to class action of a parent organization representing almost 8,000 parents. Their view is we support the mitigation efforts, all of them. Read the declaration, all of them. We support it for the health of our children, and more importantly, we are adverse to any attempt to overturn them. These are the people that Mr. DeVore says he's going to represent. He's going to represent them. Adequacy of representation. The voice of a few on minority view do not have the right to represent the majority who are completely and utterly antagonistic to them. Mr. DeVore just told you, well, they're either going to join me or they don't care. We just submitted an affidavit of an organization representing 8,000 parents. They care and they care deeply. They care and they care deeply. Mr. DeVore says in his motion, paragraph 9, quote, "No class member will be prejudiced by this cause, as each parent or legal guardian can merely choose to voluntarily require their children to comply with the mask and exclusion policies of the school district, regardless of the court's ruling on the matter," period, close quote. That's plainly false. Mr. Feeney explained it to you. Counsel for all the districts alluded to the point. Masks are a two-way street. I wear a mask, protects me, protects you. So to suggest that just because kids are running around school without masks, that doesn't mean you're hurt. You've got your mask. You've got your mask. The only medical evidence in this case from multiple medical experts, from the state parties and from the school districts, our masks are a two-way street and they protect health. The suggestion that if this temporary restraining order is granted and plaintiff even ultimately prevails on the merits of this case, that those antagonistic to the views of these plaintiffs are not harmed, it's fantasy land. And then we heard this morning, this really tops it, Your Honor. We heard this morning from Mr. DeVore, just send them home. You don't want them in the class where the kids aren't masked, just send them home. He represents those parents. He's asking for your certification to represent millions of parents. And his view is if they disagree with him, just send their kids home. I don't want it for my counsel. That is not representing the class. It is impossible for Mr. DeVore and these class representatives to adequately represent the class. Because of that, not only don't we know about Mr. DeVore's qualifications to represent a class like this, because of statements that he just made, and we've given you statements that he's made in the press, he has conflicts of interest with his own class members. This is all in our brief, Your Honor. It's a violation of Rule 1.7 of the Rules of Professional Conduct. He is completely antagonistic to the views of the people that he seeks to represent. He can't do it. He can certainly represent the views of the people that want him to carry their torch, but not the views of the people, the majority, even by a few days worth of work. The majority of the evidence in front of you is approximately 1,000 to 7,000 against. How can there be adequate representation? Mr. DeVore, when he started, said to you, you're not going to hear anybody from the other side. They don't want to protect the remaining 800,000 and 1.6 million parents. They don't want to protect them, so they're not going to hear about them. You're hearing about them from me. I want to protect them, and they're antagonistic to this class. Due process, personal jurisdiction, discovery, a class of this size without discovery before certification, plead and prove the requirements of Illinois law. It's not even kosher. On respectfully request the motion be denied.
Thank you. Mr. DeVore?
Some things never change, Judge. Some things never change. Jurisdiction. What does jurisdiction have to do with an emergency request for a restraining order?
We're not here on that, Your Honor. That's this afternoon. We're confusing.
It's the
issues already.
same, it's the same thing. It's the same thing. There is no authority whatsoever in the state of Illinois that says this court cannot, if it chooses, to conditionally certify the class right now. There's none. He cites case law to you about having to have jurisdiction over parties to enter rulings, final enforceable rulings against people. If you don't have personal jurisdiction, judgments are void. Absolutely. Let's set class certification aside for a second, Judge. If you grant relief, that relief is going to be afforded against all 146 school districts, at least to the named plaintiffs, including the ones that aren't here. Because they don't have to be served with a summons for a restraining order to be issued against them. If you had to serve a summons to get a restraining order, we would have no such thing as restraining orders. This is not a jurisdictional question whatsoever. Jurisdiction has nothing to do with it. This court can, if it wants to, conditionally grant class certification. There's no case law that says you cannot. It didn't give you any. He started giving you jurisdictional stuff about entering judgments against people, which we all know that's the law. That's not what we're here for. We're here on a preliminary request for an injunction certifying the class. The court can do it if it wants to. There's no law that says you cannot. He keeps coming around to, Judge, talking about the practicalities, what all the people that did. I would like to know how my esteemed colleague can stand in this courtroom and say, well, the people that Mr. DeVore is representing, they're in the minority. How does he know that? Maybe in the world he lives in, he thinks that my clients are in the minority, but he has no ability to come in this courtroom and say, my clients, because there's 700 to 1,000 of them, are in the minority, and he submitted an affidavit of a group of people that say we agree with the policies. Judge, see, that's the problem that we keep dealing with. Mr. Verticchio and the rest of the defendants want to make this about policy. This has nothing to do with policy. We're not here to talk about policy. We're here to talk about due process under the law. And if there is 8,000 people that don't care about their own due process, that's fine. They can do that. But to suggest that that makes them antagonistic against my clients is completely inappropriate. This court has an obligation to protect the due process rights of everyone, even those who may not want it. You know, I've stood in rooms and talked to people before, Judge, and I say, how many of you in this room like mask mandates? Nobody will raise their hand. I said, well, what if we had a rule that says you can't make people wear masks? They'll all raise their hand. And I say, you know what, that's the problem. When we come and we're concerned about the ends, then the means of which we get there, we've all lost. We've all lost. This is about due process whatsoever. Mr. Verticchio starts talking about class cases. Well, what about discovery? Discovery for what? This is not a class case where you're dealing with like asbestos or the cigarette tobacco industry where you had these huge settlements with people that were injured, etc. This is a bare bones declaratory judgment action that has commonality of due process of law. This court certifies this class. What that just means practically is that anybody that wants their due process rights afforded, you get it from me, from the court. That's all it means. There's no discovery that we have to go through to see if this class member agrees or disagrees. It doesn't change anything whatsoever. I sat there and listened to that rendition for a better part of 30 minutes, and I left it going, I don't even know what you're talking about. The reason that the motion for certification is 4 pages long is because it's not that complicated. I remember when we first started this case with you a few weeks ago, you said, look, I get it, give it to me straight. And what you still get hundreds and hundreds of pages of accusatory writings trying to make these issues more complicated than they are. Regardless of how you rule, man, these issues are not that complicated. They are not that complicated. They try to make them complicated because at the end of the day, it's no secret Mr. Verticchio is here to try to keep masks on every person in this state. That's what he wants to accomplish, and that's his job. I can respect that. But at least call it for what it is. I've never heard him, and I can't wait till this afternoon when we start talking about due process of law. When we start talking about due process of law, we don't need to talk about whether this person likes a mask or that person likes a mask. I don't care. I personally don't care about it. People want to wear a mask, wear one. If you don't want to, you don't want to. This is not an anti-mask case, ma'am. This is a case about due process, and I'm going to keep saying it over and over and over again because that's what it's about. The class certification, again, whether you grant it or deny it, it's straightforward. I keep saying to you again, just read Judge Tromper's order. For Mr. Verticchio to suggest, well, that was just one case with one school district. The analysis is exactly identical for each of these school districts. The analysis is exactly the same. It doesn't matter that there's 145 or 6 school districts. The analysis of whether you feel the class certification is appropriate or not is the same for each one of them. It doesn't change just because you have more of them. If you grant class certification, Judge, any parent that has a child in that school district that says, hey, I want my due process rights upheld, you're going to have to get an order of quarantine or modified quarantine against my child if you're trying to limit the spread of infectious disease. They'll have that right. That's it. Again, the eloquent prose that we just heard from Mr. Verticchio, none of that mattered because all we're talking about is you have that right if you want it. If you don't want it, that's okay. But if you don't want it, doesn't mean that we're going to let you turn you don't want it into we're going to keep others from being able to exercise it if they want to. That was everything Mr. Verticchio was just trying to accomplish. Is really what we want, Judge, is those who we believe, who, again, he says majority. I'm not here to give that much conjecture. I'll humbly submit I don't know. But I hardly doubt that the parent, student across this whole state that are tired of this is in the minority. I get it, but I'll digress. But Judge, that's why I'll leave you with this. That's why it's written in such simple terms. You read the 8-page order of Judge Tromper, it's not very complicated. If you want your due process rights, this court's going to afford them to you. Plain and simple. If you don't want them, you don't have to accept them. But just because you don't want to accept them doesn't mean I'm going to take it away from somebody else. And that's what they're trying to accomplish, man, and you shouldn't allow it. Thank you.
Anything in response, Mr. Verticchio?
Plead and prove, Your Honor. Plaintiffs haven't come close. Not close. And you can't enter an order, a case-altering order, against parties that are not before you, that you don't have jurisdiction over. But plead and prove, not even close. They didn't even try.
Counselor, how are you?
Thank you, Your Honor. Lisa Callaway, again,
Thank you, I'm
representing.
sorry.
That's all right. 31 of the defendant school districts.
I do remember
So-
that.
Yes, and I won't name them for you.
Thank you.
You know, it's somewhat ironic here, and I want to pick up on some of just a straightforward point that Mr. Verticchio made, and I want to also allude to your quote from your December 15th order, in which Mr. DeVore is not in compliance. We keep hearing about the due process rights of the plaintiffs, but yet at the same time, it does not seem to be relevant that the defendants have not been served, and in effect, let's ignore the due process rights, the jurisdictional issues of the defendants in this case. In your order on December 15th, you specifically directed Mr. DeVore, I'm going to quote right from it, the parties agree that no responsive pleadings are due until all parties have been served. Once all parties have been served, Mr. DeVore is to file notice indicating such. The parties have not all been served, and Mr. DeVore has not filed that notice. So speaking, taking up Mr. Verticchio's argument, to enter class certification at this juncture, when defendants have not all been served, and Mr. DeVore has not complied with your December 15th order, is frankly inappropriate at this time. Thank you.
Go ahead.
Judge, I'm quite familiar with your December 15th order, which again was what? Barely a week before the Christmas holiday? I just talked to Kevin McLean's office yesterday that's serving all of these people, and he says he'll have them to me soon, but he's working on it. So when I have them, I promise you, you will get them. But Judge, that's a red herring. That's a red herring. Service of process is not necessary. These are not responsive pleadings we're talking about. You don't need service of process when it comes to emergency injunctive relief. You've never needed it for that, and that's all we're here dealing with today. You have the ability to enter injunctive relief against every defendant named, whether they've been served or not, with summons, because they have notice of the proceeding today. They all got it. Whether they're lawyers or whether they're superintendents or senate, they got that weeks ago. So you have the ability to enter a restraining order against them. Service is irrelevant to what we're here for today. As for the issue of class certification, again, going with what Tom said, Mr. Verticchio, sorry, Tom.
That's okay, Tom.
Okay, we know each other. Judge, this is not a case-altering request. You can change class certification anytime you want. You could grant it now conditionally. You could change it a month from now, 2 months from now, if you thought it was appropriate. So it's not a class or a case-altering decision. It's case-altering for them because, again, my experience with the cases we've had injunctions in, and again, I'm use it for whatever it's worth, it's conjecture. The cases we've had injunctions in on masks, about 90% of the kids show up to school with no masks on. So what's altering for them is if we, again, I was aware that the Chicago public school system, because the teachers union wields a lot of weight up there, it seems. You take 350,000 children out of this conversation, at least for right now. But you've got, say, 600,000 kids left. You might have 500,000 kids go to school, should you grant, without masks on. They don't want that. Governor doesn't want it. It's no secret. Mr. Verticchio's here arguing for him. That's all we're talking about, Judge. This is nothing about jurisdiction, nothing about not having a summons served. It's about, well, if the judge grants the order and we can limit her to 700 and 1,000, whatever you want to call it, kids, that's better than her certifying the class, and we're now dealing with 400, 500,000. That's what they care about, Judge. That's all they care about. Thank you.
Any other defense counsel?
Can I try your patience, Your Honor? I can't believe that Mr. DeVore doesn't see the distinction. I just don't believe it. The distinction between entering a temporary restraining order with notice to the defendants, which, like the judicial notice rule I mentioned earlier this morning, that's been the law in this state for probably 100 years. You can do that. You can enter emergency temporary relief against defendants even though they haven't gotten summons and they haven't appeared if they got notice. And my guess is everybody, all the defendants got notice. That's this afternoon. We're here on a class cert motion. You can't do that unless you have jurisdiction over the parties. There is zero authority, case law, or a rule of civil procedure that allows you to enter a case-altering order binding parties that you don't have jurisdiction over. You can do it on a TRO if they have notice. That's what our Code of Civil Procedure provides. It's the one exception to jurisdiction, summons, service, appearance. I'm now before the court. And We have no idea how many of these 152 defendants are not before the court, because we have no idea how many have been served, and more importantly, of those that aren't here, if they've been served, has their time to appear lapsed? Likely not, given that service just started. Thank you, Your Honor, and I'm sorry for trying your patience.
Go ahead.
Thanks, Judge. What did you just hear? Everything that Mr. Bergicchio talked about, Judge. He's talking about the defendants. The defendants. What does class certification have to do with the defendants? Nothing. This has to do with the potential plaintiffs that could come with under the presumption that you might grant relief, who falls with under that protection. That's the plaintiffs that would be covered. The defendants who would be bound by your order, whether you certify the class or not, those plaintiffs are impacted exactly the same. Class certification merely has to do with who gets that protection. So this is not a defendant question whatsoever. If the court goes and reads the section of the statute that deals with class certification, it says the court can conditionally grant certification first available opportunity. There's no case law that says you can't do it right now. None. There's none that says you can, there's none that says you can't. The best I can tell, you have broad discretion of whether you think it's appropriate, should you grant this relief, to allow either the named plaintiffs or any other putative plaintiffs that might want to take protection under your order. It's got nothing to do with the defendants, Judge. The defendants are going to be impacted exactly the same whether you grant certification or not. The only issue for the defendants will be is who they have to let receive the due process protections that you might grant. That's the only impact of the defendants. But other than that, there's no impact of the defendants whatsoever.
Counselor?
Your Honor, James Petrangaro on behalf of Glenview School District 34. I'd like to address the court's attention to counts 10 and 11. Those are injunctions that are pled only against the school districts. Counsel seeking relief, injunctive relief, only against the school districts. They are separate and independent from the relief he's seeking against the state defendants. Counsel's named, through his plaintiffs, 145 or 146 school districts in this case. Effectively, what he's asking this court to certify are classes for each individual school district, 146 classes, because that goes to this specific relief he seeks in counts 10 and 11. Your Honor is going to hear this afternoon arguments from the school district defendants about independent authority that stands separate and apart from the state's authority under the Department of Public Health Act for the school districts, for the local school boards, to control and to protect the health and safety of their students. For Glenview 34, counsel has named 3 plaintiffs. Without an evidentiary record or any kind of record of fact in support, this court is left with only the knowledge that there are 3 plaintiffs in that school district that oppose any kind of mask policy or a remote learning plan for students that are identified as close contacts. It's completely speculative in a school district that has 8 buildings and thousands of parents for counsel to suggest that there may be other parents in need of protection. This case has been proceeding for months now, starting back before Judge Trump. To my knowledge, there has not been a single motion to intervene from any plaintiff other than those that counsel has named in his complaint to join these proceedings. There's no suggestion from anywhere across this state that there are other plaintiffs that wish to join the counts and the arguments that are brought by counsel. So I join the arguments of the other defendants who object to counsel's motion to certify and ask the court to consider specifically the impact of a certification order on counts 10 and 11 where counsel is seeking to have an injunction entered against individual school districts based upon their individual return to education plans, return to school plans.
Thank you. Any response, Mr. DeVore?
Just briefly, actually, some part of what my colleague just pointed out, he's correct, and I'm glad he made that distinction. We're asking the court to consider and certify each of the individual school districts. He's correct. So again, going back to what we were saying earlier, doing the analysis of whether you think that's appropriate, you can do it for each of those districts, you can do it as a whole, whatever, but we're asking, because we could have judged, we could have said, and a lot of people push me to, let's just certify the whole state, right? I didn't do that. We're asking you to certify each of these school districts. Suggesting, well, you only got 3 named plaintiffs opposing the mandates. Judge, I don't know how many times I'll have to say it. As long as these things continue in our state, or heck, even, I don't know if it'll ever end. This has nothing to do with opposing mandates. This has to do with we want our rights under the law. It has nothing to do with opposing them. This is not about we're anti-mask or we're anti-keep our kids home. And when you get to some of the stuff when we talk about, one of the things that, again, I always go back to it because as my colleague said, her reasoning was very thorough, is Judge Trumper said, I have no reason to believe that if parents know their children are sick or have an issue, they'll keep them home. That's right. So this is not about being opposed to your kid not coming to school, etc. This is about, hey, if I want to object, I have that right. And not just merely being told, well, you either have to like it or your kid get on down the street. That's really what this is about, Judge. It's not about opposing mandates. It's about affording due process. And 3 people as named plaintiffs, does it change if I had 30, 40, 50? No. That's not an issue for the court. The issue for the court is, do those 3 people in the relief they're asking for you, is there a commonality? And the answer is yes, there is a commonality. Thank you.
Did you want to say something, counsel?
I'm sorry.
You can.
I didn't hear 7, okay.
Melanie Rankin.
What's your last name?
Rankin, R-E-N-K-E-N. I'm here on behalf of 5 of the school districts.
Great.
Thank you, Judge. Great Satterley on behalf of my 3 school district clients, including North Mac 34, who you've heard a lot about today already this morning. I stand up only to let the court know that my co-counsel, defense counsel, has very eloquently set forth their objections, and my clients hereby adopt and incorporate those objections, and we make that point for the record with respect to class certification. We believe, Your Honor, that it's premature at this point, and that should be denied. Thank you.
Thank you. All right.
Your Honor, William Picorni, again, for Chicago Public Schools. Could we come to an agreement that, at least as far as defense counsel, so that we don't each have to stand up and adopt one another's arguments, that we can assume that arguments made on behalf of the defendants are adopted by the other defendants?
If anyone has any objection to that motion, stand up. Okay.
Thank you, Your Honor.
So that we will do that.
Well,
Hey, Your Honor, Will Gerber, I understand this isn't my motion, and I don't have the exact case in front of me, but I think the name of it is Hoffman v. LaRoche, which may be either a federal district case or U.S. Supreme Court case, dealing with class certification or conditional certification, which does not prevent at all, as Mr. Verticchio was talking about, proceeding with discovery later, going through all the procedural aspects that Mr. Verticchio was talking about, after conditional certification is provided on preliminary pleadings. So, as I said, I don't have the case specifically in front of me. I think that is the name of it. For purposes of conditional certification on temporary matters such as this, I believe it is appropriate, and it does not prevent the court later on from saying the class cannot be certified when we're dealing with specific merits of the case later on. In relation to commonality, one thing I heard from several of the attorneys in here representing the school districts was they all have different back-to-school plans. I don't think any of the attorneys representing any of these school districts can tell the court from a commonality standpoint they are not all enforcing Executive Order 18 and or Executive Order 25 for purposes of enforcement of their back-to-school policies. And a basis for enforcement of those Executive Order 25 and 18, which brought forth several lawsuits in the state, was they removed the certification status, the ISBE did. So from a commonality standpoint, that is one of the huge issues we're dealing with as a basis for the due process claims that we're talking about. Secondly, associated with both commonality and adequacy of representation, one thing that's completely being ignored is the IDPH has provisions of the law that still provides all parents, all students, the ability to come to court in the Department of Public Health to require masking in schools, and it's been done in Sangamon County on 2 separate occasions. So from an adequacy of representation, we're talking about protection of health of students or protection of health of parents, the adequacy of representation aspects. The provisions of the law that are already written that are attempted to be superseded by the executive orders in effect are completely being ignored. But I don't believe there's probably an attorney that represents one of these school districts that can get up and tell the court as basis for their back-to-school policies they are not enforcing Executive Order 18 and Executive Order 25 that are a huge question in both of these pleadings.
Thank you. Mr. Swain?
Judge Robert Swain, on that point from Mr. Gerber. I was here in your courtroom on Monday, of course, and we heard many hours of discussion between Mr. DeVore and Mr. Berticchio about the authority of the various state level officials who are involved in this case and the validity of the various mandates and regulations and guidance they have issued. We got down to the final 7 minutes of the day before you had a chance to hear perspective from school districts, and that is what's going to be so important, I submit to you, to hear this afternoon. Mr. Gerber is correct. Our 854 school districts across the state, we all currently recognize there are executive orders issued by the governor. And I think on behalf of my friends and colleagues from just about every school law firm representing probably most of the school districts throughout the entire state, we would tell you that if there's one thing our clients agree upon, is that some support the state mandates and some don't, and some wish they went further, and some wish they didn't go as far, and some wish they came come sooner, and some wish that they hadn't come at all. But what they all agree upon is that they all have local authority to make these decisions for their own children, in their own school buildings, in their own school districts. And so if we get to the point of the analysis, and Mr. DeVore prevails on his theories that these state level mandates are invalid, we are left with the still much more important analysis and consideration of what the circumstances are in each of those individual school districts. That's where we lose commonality.
Your Honor, in response to Mr. Gerber's comment, the Hoffman case that he cites is a notice case. It's a class notice case. It's not a certification case. If by the comment from Mr. Gerber, I'm not sure Mr. DeVore would agree with this, but if the request has now morphed into allowing counsel and the class, of course at their expense, because that's how it works, to give pre-certification notice, common procedure, pre-certification notice in lieu of discovery, and we could find out what these multiple millions of folks think. I have no objection to it. Order them to give notice. If they don't want to do discovery, order them to give notice. But Hoffman speaks to notice, not certification.
Okay.
All right, I changed my.
Oh, go ahead.
Yeah, I said she stood up, she changed
No,
her
ma'am,
mind.
please.
Melanie Rankin on behalf of 5 of the districts. I just want to remind the court that this isn't a lawsuit that only applies to parents and students of huge districts in Illinois. The districts that we represent are actually mostly very small districts, and their parents and students have very different needs than, depending on what district, what their geographical location is, depending on the infection rate of a certain community versus another community. And so to certify a class that would speak for every single student and every single parent in this state is completely inappropriate, in the sense that it's going back to the commonality of interest. Mr. DeVore cannot represent the interests of little Johnny, who is differently abled and is immunocompromised, and his school of 50 kids has had 30 of them are infected with Ebola. Mr. DeVore, if you could please ask the gallery to keep their opinions to
Yes.
themselves.
Only the attorneys are allowed to speak today. We are short on time and we have very pressing issues. So please, everyone's entitled to their opinion, but not today in the courtroom.
Thank you.
We're dealing with the law.
But Mr. DeVore, he doesn't represent the interests of these differently abled students or their parents, or the teacher who doesn't have the resources to put her elderly parents in a nursing home that has appropriate safeguards. So she has to make the choice of going to school and being exposed to all sorts of potentially deadly viruses and bringing them home to her elderly parents. The infection rate, again, in one county versus another is a huge factual distinction, and the school boards have to be allowed to make that decision as to what's best for their district. And one of those big components is the infection rate and the student population. Who comprises the student population and the teaching and education staff.
Mr. DeVore?
Yes, Judge. Try not to use the little Johnny analysis. I thought that was cute. Brought back old jokes. Judge, first of all, just for clarifying, we're not asking you to. This is not a statewide request. This is these individual school districts. But again, another common theme is that we, in asking for certification, you can't be asking the court to represent. And I hear all of these unique little fact patterns about this individual might be compromised, et cetera. And it's not that I'm not sensitive to that. What I'm saying is what we can with a class certification represent is, again, what we're asking you to accept as the law, because that covers everybody, right? And if we have these unique circumstances to where the law causes complications for someone, the answer is to not disregard the law. The school districts, with the laws that exist today, still have the ability to, guess what, work with the Department of Health in their communities to deal with the types of examples that my colleague just gave to the court. But given that that's in the law, you can't say, well, because of these unique circumstances, we're just going to put a blanket policy in place that says you have to do this or you're going to do that. That's not what the law says, right? So school districts, if you grant certification, and again, I agree with Mr. Swain, there's two components here. Does the state have the ability to compel these school districts to do things? Or do the school districts have inherent authority? It's two separate questions we'll get to this afternoon. But irrespective of all that, school districts have the ability to work with their health departments right now, the way the law is written, and to help protect people. Again, with what Mr. Swain says, between all of them in this room, they probably do represent most of the 850-some school districts in the state. There's 3 of them they don't represent, at least right now, because they're my clients. And guess what? At least in that courtroom, they said that the state agencies can't force these policies onto the local school districts. There's an injunction in place in Effingham County right now on behalf of Red Hill, Calton, Herrick, and Beecher City that says the state agencies do not have the authority to suspend recognition status. I think Mr. Gerber pointed out, funding and all that stuff. You can't do that. So again, I don't know Mr. Swain's specific client list that he memorized, but I do know before the governor's executive order came out, there was a lot of school districts in this state that said, we're going to go with a mask optional policy. Lots of them. There were some, a handful, that said, no, we're going to do mask required. But then when the governor came down with the thunder, all of them but now 4 have mask required policies. Well, if they have their inherent authority, why did they all but 4 change? One of them was in front of you last year, Hudsonville. Remember them?
I do.
You do?
What
So-
case was that, Tom?
Huh?
What case was that?
Hudsonville?
Oh,
Yeah, the Hudsonville. Yeah, well, we're going to talk about that this afternoon. But my point to you is, Judge, is that this, and again, Mr. Swain brings up a good point. We will be talking about the state's authority to compel anything, and do the school districts have their own inherent authority? I assure you, the state will not be happy if you rule that they can't do it, but school districts can, because I would imagine within a matter of a week, there's going to be hundreds of school districts that are going to go back to mask optional policies. But again, we'll get to that this afternoon. Thank you.
Last one.
Briefly, Your Honor, this is Alan Yao for Pleasant Hill Community Unit School District Number 3.
I'm sorry, for who?
Pleasant Hill Community Unit School District Number 3. I just want to make it clear for the record that my client is not taking a position on plaintiff's motion to consolidate the class or to certify the class.
Thank you. Okay.
Your Honor, if I may. Very
No,
briefly.
I said he was the last one. Go ahead.
Okay. Randall Slade on behalf of 11 school districts. I just want to make clear that I do join the objections and comments of my co-colleagues, so I'll be as quick as possible. I've handled a number of class actions, and I think there's a very significant distinction between a TRO hearing, which I have a case here passed at the TCR 242 LF 3B 259. Describes what a TRO hearing is. It's a summary proceeding. It's law and argument. We don't have witnesses. A class certification matter is very different, and it's based on evidence. It's based on affidavits, discovery. No discovery, as Your Honor, I'm sure knows, has been taken in this case, and that's would be prejudicial to my clients on this motion if you are going to grant class certification today. So I just want to make that clear, and some of the other counsel have raised.
What was the name of that case? I got the site, but I didn't get the name.
Passon, PASSON,
Okay.
And that's, that's more of a TRO case than a class certification case. But there are 2 distinct statutes with 2 distinct requirements, and you can't just meld them together like Mr. DeVore is trying to do. So, and the other point I wanted to make that hasn't been raised today is Mr. DeVore began speaking about, we might be overwhelmed with joinders if this case goes forward. Well, under the class action statute 4B, the court's going to be overwhelmed with exclusions if this motion is granted as well. So every class member has that right, and I think you're going to find that as I think pretty much everyone in this courtroom agree, there are very different opinions on these issues. And that's specifically what makes class certification appropriate is that difference. 8013 says the class representatives have to fairly and adequately protect the interests of the class. And that's something you do through discovery and determine whether or not they can fairly and adequately protect the interests of the class. A class action is appropriate for fair and efficient method for adjudication. Those differences are what make this an inefficient method for adjudication, and those differences are why the class representatives cannot fairly and adequately protect the interests of the class. Thank you.
Thank you. All right, just so I'm clear, you're seeking class, but I didn't think you were in 05, but in light, I think, of what Mr. Perticchio said, there's no class certification in 05.
05 is the Montgomery County case. That was already certified by Judge Drunken.
That was certified. Early sight of the ruling in the 5th District in Lurkins. I think that would also, as Mr. Verticchio has argued, would have dissolved the class. There's no TRO in place. There was a motion to certify in the underlying case. There's not a motion to certify in that case pending today. Is that accurate, Mr. DeVore?
Sure, there's not, Judge, but the certification order of Judge Drunke was a specific separate order that was entered in that case. The TRO was eventually dissolved, no doubt, but the order for class certification is still in full force. There was no vacating of that order or anything in the record to suggest the same.
I suppose if necessary, Your Honor, that's something we'll have to take up at a later date. I'm certain the AG would oppose the validity of an order that was entered prior to their appearance based on arguments earlier today.
We were not even named defendants in that suit at the time of this certification, Your Honor.
Okay.
So it's even farther removed in terms of personal jurisdiction. We weren't even a party.
So I just want to clarify, the
Yes.
motion for class certification before me is in 02.
That's correct.
Yes.
All right,
Absolutely.
okay.
Yes.
In light of the time,
We're not trying to meld them together. We're asking the court to consider both of them, which we can do. This court can absolutely, right now, if it chooses to, enter a conditional class certification, if it wants to. There's no law, you've not been given any, that says that's improper. None. Now, my colleague talks about, because this came up in the other 3 cases where certification was granted, well, people can exclude, ask to be excluded. My colleague's correct. You know how many asked, Judge? None. And you know why? It's because those who disagree well, the court entered an order that says that if you don't want to do these things, you have due process under the law. And those that would say, well, I don't like that, I want to be excluded, well, it doesn't have, the ruling does not, from a law perspective, law, not about whether they don't like the order or not, doesn't impair them. So nobody's going to ask to be excluded. And if they do file to ask to be excluded, how does their life change? It doesn't. Now, they might be mad because their neighbor's kid's not wearing a mask, but getting excluded from this case doesn't benefit or help them with that. So joinder is a real issue. Join, nobody's going to exclude because it provides them no benefit whatsoever. Again, when you're trying to figure this out, Judge, of whether you think it's appropriate or not, penalties of this case, because again, you look at class certification on a case-by-case basis. If I certify, what happens? That means the plaintiffs named in this case for a school district, plus any other parents within that school district that are wanting their children's due process rights to be upheld will have that protection of this court's order. That's it. There's nothing unique. There's not rights. That's all. Thank you. We rest.
Your Honor, in terms of Montgomery County, there were no objections filed because notice to the class was never sent. The TRO was dissolved on the very day that the court would have reviewed notice to the class. So there were no objections to the class because the class notice never went out.
Has it gone out in this case?
That was after Judge,
Oh, you mean after the judge certified it and then the notice?
yes,
The plaintiff sends it all out?
Correct, Your
Gotcha.
Honor. There was a representation that there hadn't been
Gotcha.
objections to the class, but that's partly because the class had never been notified.
and just so practically, so the court's aware, what